all special
For weeks now, one of the most recognizable names in entertainment has said nothing, at least not about the allegations now attached to his name. A bombshell lawsuit filed in California accuses a global superstar and his management company of sexual harassment and retaliation. The claims come from a professional musician who says what began as a career-defining opportunity quickly turned into a situation that left him feeling unsafe, unheard, and ultimately unemployed. Since the lawsuit became public, the accused has continued posting, traveling, promoting new projects, and appearing on late-night television, while remaining completely silent on the case itself. But court records may be quietly revealing what's happening behind the scenes. So what exactly is being alleged? How strong is the legal connection to the celebrity at the center of the case? And what does the law actually require for this lawsuit to move forward? This is not about internet speculation. It's about legal strategy, courtroom standards, and what happens when fame collides with formal allegations. Let's break down what we know and what comes next. At first, it looked like the kind of opportunity most artists only dream about. A professional violinist, known for blending classical technique with modern performance, had built a reputation as a rising talent. He had appeared on national television, toured independently, and cultivated a growing audience online. Like many musicians, he understood how rare it was to get noticed by someone at the highest level of the entertainment industry. So when he was contacted by representatives connected to a world-famous actor and musician, he took the outreach seriously. According to the lawsuit, the initial contact came in late 2024. The violinist was invited to a private meeting at the celebrity's home, framed as an introduction and a possible collaboration. During that meeting, he performed, played his music, and discussed creative ideas. The interaction, as described in the complaint, felt encouraging. He was told his talent stood out. He was made to feel valued. Shortly after, the opportunity expanded. The musician was invited to perform at a live show in San Diego. He accepted. The performance went well enough that he later posted about it publicly, describing sold-out nights and expressing gratitude for the chance to share the stage. On stage, the celebrity reportedly introduced him to the audience, reinforcing the impression that this was more than a one-off appearance. Behind the scenes, conversations continued. The lawsuit claims that the celebrity expressed a sense of personal and creative connection, allegedly telling the violinist that they shared something special that did not exist with others. Whether that statement was meant as professional praise or something more would later become a point of contention, but at the time, the musician interpreted it as a sign of trust and momentum. That momentum came with expectations. The violinist alleges that he was invited to become part of a multi-month tour scheduled for 2025. Relying on that representation, he says he made significant financial and personal commitments. He purchased new music equipment. He secured medications. He adjusted his schedule and turned down other opportunities in anticipation of the tour. This, he claims, was not casual involvement. This was employment. By early 2025, the tour was underway. The musician joined the production team at various stops, including a Las Vegas performance. Hotels were booked by the tour organizers. Travel and lodging were coordinated centrally. According to the complaint, access to his hotel room was limited to him, hotel staff, and individuals connected to the tour. It was during this leg of the tour that the situation allegedly changed. On March 20th, the violinist claims he returned to his hotel room to find signs that someone had been there without his knowledge or consent. There was no sign of forced entry. Instead, he alleges that he found items that did not belong to him and a handwritten note addressed to him by name. The note, according to the complaint, suggested a return time and implied an intimate encounter. The discovery alarmed him. He claims that hotel security told him there was no evidence of a break-in, which only deepened his concern. If no forced entry occurred, then whoever entered the room may have had authorized access, or at least access that did not trigger security alarms. Fearing for his safety, the musician took action. He documented what he found. He contacted hotel security. He changed rooms. He also contacted the non-emergency police line to create a record of what had occurred. Importantly, he reported the incident to tour management, believing that notifying his employers was the appropriate and necessary step. This report, according to the lawsuit, marked the turning point. Instead of receiving support or an investigation, the violinist claims he was met with skepticism. He alleges that management questioned his account and suggested the incident never happened. Within a short period of time, he says he was informed that he was being removed from the tour. The stated reason, he alleges, was vague, that the tour was moving in a different direction, but the complaint argues that this explanation was not genuine. According to the filing, after his termination, another violinist was hired to fill the same role. To the plaintiff, this suggested that his removal had nothing to do with artistic direction and everything to do with the report he made. From his perspective, the message was clear. Speaking up cost him his job. The lawsuit does not allege that the celebrity physically assaulted the musician. Instead, it centers on claims of sexual harassment, unsafe working conditions, and retaliation. The plaintiff argues that the alleged hotel intrusion, combined with prior comments and the aftermath of his report, created a hostile environment and violated multiple California labor and civil rights laws. He further alleges that the stress of the incident and his termination caused severe emotional and physical harm, including anxiety, PTSD-like symptoms, and reputational damage within the music industry. The defendants, both the celebrity and a management company associated with him, have categorically denied the allegations. Through counsel, they have described the claims as false, baseless, and reckless, stating that they intend to fight the lawsuit through all available legal means. At this stage, no court has ruled on the merits of the case. What exists now is a legal complaint, formal denials, and a growing public debate about accountability, power dynamics, and the responsibilities of employers, especially when fame and influence are involved. This case is not about internet rumors or anonymous accusations. It is about whether the law recognizes retaliation, whether workplace safety obligations were breached, and whether a celebrity can be held individually responsible for actions connected to their professional operations. As the legal process unfolds, the central question remains unresolved. Was this an artist punished for reporting a safety concern, or a misunderstanding elevated into a lawsuit by circumstance and perception? The answer will not come from social media posts or silence. It will come from motions, evidence, and the slow machinery of the court system. And this is only the beginning. As the lawsuit moved from public shock to legal scrutiny, the focus shifted away from headlines and towards structure. In civil litigation, especially cases involving high-profile defendants, the story that matters most is not the one told on social media, but the one that survives legal standards. And that is where this case now stands. At its core, the lawsuit is not framed as a traditional sexual assault claim. Instead, it is built around retaliation, workplace safety, and civil rights violations under California law. That distinction is critical because it determines what the plaintiff must prove and what the defendants are legally required to answer. The plaintiff's legal theory is relatively narrow but serious. He alleges that after reporting what he believed to be a sexually motivated and unsafe incident, he was terminated from his position. Under California law, reporting sexual harassment or workplace safety concerns is considered protected activity. An employer may not lawfully punish an employee for doing so. If the termination was motivated, even in part, by that report, it could constitute illegal retaliation. That is the spine of the case. To support that claim, the plaintiff relies on timing and circumstance. He argues that he reported the hotel incident, that management dismissed his concerns, and that he was fired shortly afterward. He further points to the hiring of another violinist as evidence that the stated reason for his termination, that the tour was moving in a different direction, was merely a pretext. In legal terms, this is a familiar framework. Courts often evaluate retaliation claims by asking three basic questions. Did the plaintiff engage in protected activity? Did the plaintiff suffer an adverse employment action? Is there a causal connection between the two? On paper, the plaintiff alleges all three, but alleging is not proving. Where this case becomes more complex is in its attempt to link individual liability to the celebrity defendant. While the management company's involvement is more straightforward, employers can be held responsible for retaliatory termination. The individual defendant presents a higher bar. The lawsuit includes allegations that the celebrity made comments suggesting a special or exclusive connection with the plaintiff. It also suggests that the celebrity's position of authority over the tour meant that decisions like termination would not have occurred without his knowledge or approval. This is what legal analysts often refer to as the connective tissue problem. To hold an individual defendant liable, the plaintiff must do more than show proximity or influence. He must show that the individual either directly participated in the unlawful conduct or knowingly ratified it. Courts do not impose personal liability simply because someone is famous, powerful, or at the top of an organizational structure. This is where defense strategy becomes relevant. Legal experts expect the defendants to challenge the complaint early, likely through a motion to dismiss. Such a motion does not argue whether the allegations are true or false. It argues that, even if they are assumed true, they are legally insufficient to proceed. In this case, a motion to dismiss would likely target several areas: whether the complaint sufficiently alleges that the celebrity personally engaged in harassment, whether the alleged comments rise to the level of legally actionable conduct, whether the hotel incident can be reasonably linked to the defendants at all, whether the plaintiff has adequately pleaded causation for retaliation. The hotel incident, in particular, is a pressure point. The plaintiff alleges that someone entered his room without consent and left items suggesting a sexual encounter. However, the complaint does not identify who entered the room, how they accessed it, or whether that person had any connection to the defendants. At this stage, the allegations rely on inference rather than direct proof. Inference is allowed at the pleading stage, but only to a point. Courts require allegations to be plausible, not speculative. If the defendants can show that the complaint lacks facts tying the intrusion to them, that portion of the case may be vulnerable. That does not automatically defeat the retaliation claim, but it weakens the narrative foundation on which it rests. Another significant aspect of the lawsuit involves California's civil rights statutes, including the Bane Act and the Ralph Act. These laws address coercion, intimidation, and violence based on protected characteristics such as sex or sexual orientation. Invoking these statutes raises the stakes. However, these claims also require specific showings, namely that the defendant engaged in threats or violence motivated by a protected characteristic. The plaintiff argues that the hotel incident and its aftermath meet that standard. The defense is expected to argue that the allegations do not satisfy the statutory requirements, particularly in the absence of identified perpetrators or explicit threats. Throughout all of this, the celebrity defendant's public silence has remained consistent. From a legal perspective, this is not unusual. Statements made outside court can be used in litigation. Silence, by contrast, carries no evidentiary weight. Continuing professional activities, travel, promotion, appearances, signals confidence without creating legal exposure. This is standard crisis management for high-profile defendants. It is also important to note what has not happened yet. There has been no discovery, no depositions, no document production, no sworn testimony. At this stage, everything is confined to pleadings and preliminary analysis. The court has not weighed credibility, assessed evidence, or made any factual findings. That process, if it occurs, will come later, and only if the case survives early challenges. For the plaintiff, the next hurdle is procedural survival. If the case moves forward, discovery could provide clarity: emails, tour communications, hotel records, access logs. These materials could either strengthen his claims or expose weaknesses. For the defendants, early dismissal would limit exposure and prevent invasive inquiry into personal and professional matters. This is why the case now sits in a strategic pause. Public attention may ebb and flow, but the real action will happen in filings, motions, and judicial rulings. The law will decide not who is more famous, but whose claims meet legal standards. And until then, one reality remains unchanged. Allegations alone do not decide cases. Evidence does. The next phase will determine whether this lawsuit becomes a full courtroom battle or ends before it truly begins. Once the initial shock of a high-profile lawsuit fades, civil litigation enters its most decisive phase: procedure. This is where cases are often won or lost long before a jury ever hears a word. If this lawsuit proceeds on its current trajectory, the next critical step will be the defendant's formal response. That response will almost certainly shape everything that follows. The motion to dismiss. The first legal gate. The most likely immediate move by the defense is a motion to dismiss. This motion does not argue innocence or guilt. Instead, it argues that, even if every factual allegation in the complaint is assumed to be true, the law does not recognize those facts as sufficient to support the claims being made. In practical terms, the defense will be saying, "This lawsuit does not legally add up." Courts grant motions to dismiss when complaints rely too heavily on speculation, fail to establish causation, or attempt to stretch statutes beyond their intended scope. In cases involving celebrities, judges are often especially careful to separate reputational impact from legal sufficiency. For the plaintiff, surviving a motion to dismiss is essential. If the court dismisses the case outright, the lawsuit ends before discovery. Sometimes plaintiffs are allowed to amend their complaint and try again, but repeated failure often signals the end of the road. Discovery, where allegations become evidence. If the case survives dismissal, it moves into discovery, the most invasive and consequential phase of civil litigation. Discovery is where the lawsuit stops being theoretical. During discovery, both sides can demand emails and text messages, tour planning documents, internal communications, hotel booking records, security logs, personnel decisions and termination records, deposition testimony under oath. For the plaintiff, discovery is the opportunity to prove what he has only alleged so far. This is where he would need to establish who had access to his hotel room, whether anyone connected to the defendants entered it, who made the decision to terminate his role, what communications occurred after he reported the incident, whether the stated reason for termination was genuine or pretextual. For the defendants, discovery carries risk of a different kind. Even if they believe the claims are weak, discovery opens the door to scrutiny of internal operations, management practices, and private communications. For high-profile individuals, this can be costly, not just financially, but reputationally. This is why many celebrity defendants aggressively seek early dismissal. The retaliation claim, still the strongest thread. Among all the claims asserted, legal analysts consistently point to retaliation as the plaintiff's strongest theory, at least structurally. If the plaintiff can demonstrate that he reported a safety or harassment concern, the report reached management, he was terminated shortly afterward, the termination justification does not withstand scrutiny, then a court may allow the claim to proceed even if other claims fail. Timing matters in retaliation cases. Courts often consider how quickly an adverse action follows protected activity. A short time gap can support an inference of retaliation, though it is not dispositive on its own. The defense will counter this by arguing legitimate business reasons, performance issues, creative direction changes, logistical decisions. If they can show that the termination decision was made independently of the report, the retaliation claim weakens significantly. Individual liability, still an uphill battle. The plaintiff's attempt to impose individual liability on the celebrity defendant remains one of the most contested aspects of the case. Courts are cautious when plaintiffs seek to hold individuals personally liable for actions taken within a corporate or managerial structure. The plaintiff must show more than influence or authority. He must show direct involvement or knowing approval of unlawful conduct. This is not impossible, but it is difficult. Without emails, directives, or testimony tying the individual defendant to the termination or alleged harassment, courts are often reluctant to let such claims proceed. This is where discovery could either save or sink that portion of the case. Settlement, the quiet middle ground. Even if both sides publicly posture for battle, most civil cases resolve through settlement. Settlement does not require an admission of wrongdoing. It is often a strategic decision to avoid prolonged litigation, unpredictable juries, or reputational harm. For celebrities, settlement can be a way to close a chapter without keeping allegations alive for years. That said, settlement cuts both ways. For plaintiffs, settlement offers certainty and closure, but often less than what might be awarded at trial. For defendants, settlement avoids risk but may invite public speculation. Whether settlement discussions occur often depends on what emerges in early motions and discovery. Strong early defense victories reduce settlement pressure. Surviving dismissal increases it. Public silence versus legal noise. One of the most misunderstood aspects of high-profile litigation is silence. From the outside, silence can look evasive. Inside the legal world, it is discipline. Every statement made publicly can become evidence. Every denial can be parsed. Every emotional reaction can be mischaracterized. For that reason, defense attorneys almost always advise clients to say nothing and let filings speak. Continuing to work, travel, and promote projects sends a subtle but intentional signal: confidence without confrontation. It is not a legal defense, but it is a strategic posture. The long view. At this stage, no court has ruled on the merits. No evidence has been tested. No credibility determinations have been made. The lawsuit exists in a narrow procedural window where allegations matter, but structure matters more. The next filings will determine whether this case becomes a prolonged legal battle or ends quietly through dismissal or resolution. What is clear is this: the outcome will not be decided by headlines, social media reactions, or public opinion. It will be decided by documents, testimony, and whether the plaintiff can transform suspicion into proof. And until that happens, this case remains exactly what it is right now: an allegation waiting to meet the law. Every high-profile lawsuit eventually reaches a point where strategy gives way to reality. Motions are decided, evidence is tested, and both sides are forced to confront the same question: how does this actually end? For this case, there are only a handful of realistic outcomes, and none of them look like the viral narratives that often dominate social media. Scenario 1. Early dismissal. The most decisive outcome for the defense would be an early dismissal, either with prejudice or after the plaintiff fails to amend the complaint successfully. If the court finds that the allegations, particularly those tying individual liability to the celebrity defendant, are legally insufficient, the case could end before discovery ever begins. This would mean no depositions, no internal documents disclosed, no trial, no settlement pressure. In practical terms, it would be a clean, legal victory. Publicly, however, even dismissal does not erase allegations from public memory. High-profile defendants often win in court while still dealing with lingering reputational consequences. That is the cost of fame intersecting with litigation. For the plaintiff, dismissal would be devastating, not only financially but professionally. It would likely foreclose further civil action based on the same facts. Scenario 2. Partial survival. Another likely outcome is partial dismissal. Courts often allow certain claims to proceed while dismissing others. In this case, that could mean retaliation claims survive against the management company, individual claims against the celebrity are dismissed. Civil rights statutes, Bane Act, Ralph Act, are narrowed or removed. This outcome would significantly reshape the case. It would reduce public focus on the celebrity defendant while shifting attention toward employment practices and corporate decision-making. The litigation would become less sensational, but more legally grounded. Partial survival also increases the likelihood of settlement, as both sides face continued cost and uncertainty. Scenario 3. Discovery and escalation. If the lawsuit survives motions and enters discovery in full, the dynamics change entirely. At that point, the case becomes expensive, time-consuming, and unpredictable. Depositions under oath carry risk. Documents can be misinterpreted. Third parties, hotel staff, tour personnel, managers may be pulled into the process. For the plaintiff, discovery is the only path to proving intent and causation. For the defendants, discovery is often the most dangerous phase, not because they expect to lose, but because discovery has a way of expanding beyond its original scope. This is where many celebrity cases quietly resolve. Scenario 4. Settlement without admission. Settlement is not a concession of guilt, it is a risk calculation. If settlement occurs, it will almost certainly include no admission of wrongdoing, confidentiality provisions, carefully worded public statements, closure for both sides. The public often misunderstands settlement, equating it with guilt. Courts do not, lawyers do not, businesses do not. Settlement means one thing: both sides decided certainty was better than chance. What a trial would actually look like. Despite public fascination, a full jury trial is the least likely outcome. Trials are messy, witnesses are unpredictable, jurors bring their own biases, and in cases involving celebrities, the risk of emotional verdicts increases. If this case ever reached trial, the jury would not be asked to decide internet theories. They would be asked to answer narrow legal questions. Was the plaintiff retaliated against for protected activity? Did the defendants act unlawfully under California employment law? Can liability be proven by a preponderance of evidence? Trials are about proof, not suspicion. The reputation factor, regardless of outcome. This case highlights a recurring truth in modern litigation. Legal innocence and public perception are not the same thing. For plaintiffs, speaking out can be career-ending if claims fail. For defendants, silence can be misread even when legally necessary. This tension is not resolved by verdicts alone. It is resolved over time. The broader implications. This lawsuit sits at the intersection of several modern realities: gig-based creative work, informal employment structures, power imbalances in entertainment, evolving workplace safety standards, heightened public sensitivity to harassment claims. Courts are still adapting to these realities. That means outcomes are less predictable than they once were. But unpredictability does not mean lawlessness. The law still demands evidence. It still demands causation. It still demands clarity. Where things stand now. As of now, no court has ruled on the merits, no evidence has been tested, no liability has been established, no credibility has been assessed. Everything remains allegations. The next filings, motions, responses, and rulings will determine whether this case becomes a cautionary footnote or a landmark dispute. Until then, one principle must remain front and center. Allegations are not conclusions. They are the beginning of a legal process, not the end. And in that process, only one thing ultimately matters: what can be proven.